Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Jacqueline Opoku, and today we'll be discussing discharge of contract under contract law in Ghana. So far, we have discussed how contract is formed, looked at the vitiating factors that make an otherwise enforceable contract unenforceable. We also discussed illegality of a contract and its effect on the obligations of the parties. Today we'll be discussing discharge of a contract, meaning we've come to the end of the performance of the contract and therefore the parties are free to go away or to go on their own. When we talk about discharge of a contract, we must know the meaning of discharge of a contract, the four types and the exceptions thereto to any of the types. Our discussion will border on the main types of discharge of a contract and also if there are exceptions and what the court deems to be a contract which has been discharged by the parties. Therefore, what is discharge of a contract? Discharge of a contract simply means that the termination of a contract or a contract which has come to an end and therefore the parties are no longer bound by the obligations under the contract. When a contract is fully performed, the parties have agreed, or there are situations that causes the contract not to be able to be performed, or situations where the parties will perform the contract. In these situations, the contract will be said to have been discharged or the contract would be said to have come to an end. There are four main types of discharge of a contract. The first one is discharge by agreement. The second one is discharge by performance. The third one is discharge by frustration. And the last one is discharge by breach. We'll be focusing on discharge by agreement in the first part. Discharge of a contract by agreement simply means that the parties have come into terms that the said contract that they have entered into should come to an end. This is because the parties have come to realize that so far they have been able to do what they were supposed to do, or they have performed the contract to the maximum, and due to that effect, they want the contract to come to an end. A contract may come to an end by the agreement of the parties, as held in the case of Japan Motors versus Randolph Motor. In that case, the court held that a contract for which the parties have agreed for it to come to an end will be said to have been discharged, and stated that discharge by agreement can be a contract where a new one substitutes the old one. This introduced us to the fact that under discharge by agreement, there are certain circumstances under which a contract will be said to have been discharged by the agreement of the parties. A contract will be said to have been discharged by the parties by their agreement is when the parties both mutually agree that the contract should come to an end. In such a situation, both parties will agree that the contract should come to an end due to the fact that 1. They have performed their part, 2. They do not want to be bound by the contract any further, and therefore the contract should come to an end by mutual agreement or mutual rescission. Another way by which a contract may come to an end by mutual agreement is where the party expressly states in their agreement that when they achieve a certain level of satisfaction or a certain level of performance, the contract should come to an end and therefore will be deemed to have been discharged of their duties and no longer bound by the contract. Another reason for which a contract will come to an end by mutual agreement is where the parties agree that a new contract for which they have entered into should substitute the old contract that they had already entered into. For example, A and B being in a contract, A being the seller told B that he will sell a table to B, and therefore once A has sold the table to B, it will be deemed that the contract has come to an end. But in such a situation, A and B can agree that although the table was the main agreement or was the first agreement, if B sells a chair to A, the contract will still be deemed to have come to an end. Mind you, the old contract was that A was supposed to sell a table to B, but then they agreed that for now, B should sell a chair for the contract to be discharged, or for the contract to be deemed to have come to an end, and that the parties are being discharged of their duties. This was seen in the case of Japan Motors versus Randolph, where the court held that where parties do agree that a new contract should substitute, or a new contract should be held to be the contract that will bind the parties, once the new contract is being discharged, the parties would be deemed to have discharged their duties and therefore no longer bound by the contract. In the case of Fish and Meat versus Ethusa, the court held that where parties by a letter write to the other that they want the contract to come to an end, and the other party replies or accepts for the contract to come to an end, it will be said to be discharge of a contract by mutual agreement. We have looked at what discharge of a contract is and have said that there are four main types of discharge of a contract. We have looked at the first type to be discharge of a contract by mutual agreement. We'll be moving to the second type, which is discharge by performance. Under discharge by performance, the old law, the common law, was that for a contract to have been said, or for a contract to be said to have been performed, the parties must fully and completely perform their obligations under the contract. In this sense, the law stated that if the parties perform partly, or they even perform substantial parts, and they have not completely performed the contract, it will be said that the contract has not been performed, and therefore discharge cannot be said to have occurred. In simple terms, under the common law or under the old law, the law was that for you to say that you have performed your contract and therefore you should be discharged of your duties, the said contract should have been fully completed. There should be no lapse, or there should be no gaps for you to fill. You have performed the contract to the brim of the contract, and therefore that is when you can say that you have discharged the contract. But then with the evolution of law and with the evolution of the doctrine of equity, there are certain situations where even though the contract is not fully performed, the court will say that although the contract is not fully performed, the parties can still be discharged of their duties. The first exception is the doctrine of substantial performance. The doctrine of substantial performance operates as an exception to the common law rule that a contract should be completely be performed before it can be deemed that the parties are being discharged of their duties. For substantial performance, it simply means that the parties have performed their obligations to the maximum, or to the point that the part which is left for them to fulfill is trivial, and therefore can be deemed that the party has fully performed their contract. Mind you, they have not fully performed the contract, but they have performed the contract in such a manner that the part which is left is very small, or it is minimum or minimal, or it is trivial, that the parties can go ahead and be discharged of their duties. In the case of Honing versus Isaacs, the court held that under common law, a party can only be discharged where he has fully performed his part, but due to equity and due to the evolution of the law, where a party substantially performs his part of the contract and the part left is trivial, the court would deem that the parties have performed their contract and therefore can be discharged of the duties. With this, in the same case, Honing versus Isaacs, the court went ahead or further held that although substantial performance can discharge the parties of their obligations under the contract, the other party can sue, or the other party can counterclaim for the trivial part which has not been performed by the other party. In simple terms, where a party claims that he has substantially performed his part of the contract and therefore should be discharged of his duty, he will be discharged, but the other party can sue or can counterclaim and tell the court or pray to the court that yes, the other party has substantially performed his part, but the part which is left, or the small part which is left that he has not performed, I am counterclaiming, or I am suing to enforce for that part to be performed. And also in the same case, the court held that where a party substantially performs his part, he will be entitled to the contract price, and the other party can now sue to claim for the part which has not been performed by the other party. The other exception for us to note is the doctrine of part performance, which exists under the doctrine of equity. The doctrine of part performance simply means that a party has performed parts of the obligations he is deemed to perform under the contract, meaning the contract has not been fully been performed, but he has performed half of the contract or part of the contract, and therefore can ask the court or pray to the court to discharge him of the contract. In this situation, the court has held that for part performance to suffice as suffice to discharge a party of his obligations under the contract, the other party must accept the part performance which was performed by the other party. In simple terms, if you claim to have performed part of your obligations and therefore you are seeking the court to discharge you of your duty, you must ensure that the other party, who is also a party to the contract, should have accepted your part performance and is ready to allow you to be discharged of your duties under the contracts for which you agreed or entered to perform. The case of Mafsalt versus Farah Bros Limited, the court held that for part performance to allow a person to be discharged of his duties which is bound by him under a contract, the other party must fully accept that the part performance should operate as if the contract has been otherwise fully or completely performed. The other exception to the general rule of complete performance is where a promisee prevents you from completing the particular assignment the promisor can still claim. Meaning, if you are entitled to perform or you are obligated to perform your part in a contract and you are ready to perform your part under the contract, but then the other party prevents you from performing the contract, it can be deemed that you are being discharged of your performance under the contract. In the case of Planch versus Colburn, the court held that where the promisee prevents the promisor from fulfilling his obligation under the contract, it will be deemed that the promisor has fully completed the performance of his part of the contract and therefore is discharged of his duties under the contract. I will encourage you to read the cases that have been mentioned in this video. So far, we have looked at the two types of discharge of a contract, and the first one we considered was discharge by agreement, and the second one is discharge by performance. The next one we are to consider is discharge by breach. And the discharge by breach, it simply means that where a party fails to fulfill his obligation under a contract, or where a party who is supposed to perform a contract does not perform and therefore breaches the contract, the other party would automatically also be deemed to be discharged of his duties and therefore will not be bound to perform his duties under the contract. And the discharge by breach of a contract, there are two factors or two things that must happen for the party who did not breach the contract to sue or to be discharged of the duties he has under the contract. The first one is where there is a fundamental breach, then the innocent party can discharge himself of the contract. Simply, if you breach a contract, or if a contract that exists between two parties and one party breaches the contract and the breach is conditional, or it is a breach of a condition in the contract, then the innocent party that did not breach his part of the contract will be deemed to have been discharged of his duties under the contract. Meaning, if the contract which has been breached is not fundamental, or the breach is not fundamental or does not go into the core of the contract, then the other party cannot be said to have been discharged. The second exception is that where there is an anticipatory breach. An anticipatory breach simply means that the contract that you have entered into, you believe that due to the actions being displayed or the conduct of the other party is likely to breach the contract in the future. In anticipatory breach, the contract has not yet been breached, but you have reasonable grounds to state that the contract, looking at the conduct or the words or the actions of the other party, it is likely that the other party will breach the contract in the future. In the case of first versus ninth, a man promised to marry a woman and stated that he will marry her before the father dies. In the course of their relationship, the man got married to another person and the plaintiff sued to enforce the contract and stated that although he has not breached the contract yet, looking at the fact that he has married another woman, the contract is said to be breached in the future. The court held that anticipatory, in situation where a party claims anticipatory breach and the grounds for which he is claiming under are reasonable, he or she will be discharged under the contract or will be discharged of his duties under the contract. What is the remedy available for anticipatory breach? There are three remedies available to the innocent party who claims that the other party is likely to breach their contract in the future. The first remedy is the innocent party can decide to accept the breach and consider himself discharged and sue for damages. Anticipatory breach is held to occur in the future. The innocent party can decide that you have said that you want to breach the contract, or your actions show that in the near future you would likely breach the contract. I do not care. I will still wait for you to breach the contract in the future and sue you for damages. In this situation, the person will not sue under the anticipatory breach. They will sue only when the breach has actually occurred. And when the breach actually occurs, they will sue and pray that the court grants them remedies or grants them damages under the contract. The damages could either be special or general damages. In the case of Rochester versus Delator, in this case, the court held that an innocent party in an anticipatory breach can decide to wait for the party who is deemed to breach the contract in the future, and when that party breaches the contract in the future, the innocent party can sue for damages. The second remedy is that the innocent party can affirm the contract and wait for the due date to make the breach happen. This is similar to the first one, but here the innocent party will state that go ahead, or I'm waiting for you to breach, and when you breach the contract, I will sue you for damages. In this situation, the innocent party is entitled to damages only if he can prove that he affirmed the contract, meaning he performed his part of the contract and waited for the other party to not perform his part of the contract and sued the other party for the breach. For the first one, the innocent party will accept that, yes, you want to breach the contract, go ahead and breach it, or I'll wait for you to breach it. But in this second exception, the innocent party will go ahead to perform his part of the contract, knowing very well that the other party intends to breach the contract in the future and will wait for the contract to be breached before he sues for damages. In such a situation, the court will grant the innocent party the prayers that he prays before the court and the reliefs that he or she seeks before the court. You can look at the case of Avery versus Bolden, where the court stated that an innocent party can decide to affirm the contract by performing his part of the contract and waiting for the other party to breach the contract and sue for damages. The third remedy is that the innocent party can go ahead and affirm the contract, wait for the breach to occur, and hold the contract binding on the other party. Meaning he's not going to sue for damages, but he's going to sue for the other party to perform their part of the contract. Meaning he will sue for specific performance. In situations like this, the party who has affirmed the contract, affirmed or performed the contract because they know that monetary damages cannot put them back or cannot restitute them to the position they were before the breach occurred. And due to that, the court will allow the party to sue for specific performance, entitling the other party to perform the contract as if the breach had never occurred. We have looked at discharge by performance, discharge by agreement, and discharge by breach of contract. The next or the last thing to consider under the discharge of a contract is discharge by frustration. Discharge by frustration simply means that a contract which the parties have entered into, and looking at the contract, both parties are ready to perform their obligations under the contract, but due to unforeseen circumstances by both parties, the contract cannot be performed. In such a situation, the court will discharge both parties from performing their duties under the contract. I will take it again. Under discharge by frustration, both parties are ready to perform the contract. Nobody has the intention to breach the contract, or they do not have any agreement that although the contract is not performed, we should bring the contract to an end. They are ready to perform the contract, but due to certain unforeseen circumstances or events like fire outbreak, acts by God, or situations where the parties did not contemplate that it will happen, but it has happened, and due to such a situation, the contract cannot be performed by the parties. This is called discharge by frustration. Under discharge by frustration, we will look at some of the examples or some of the situations where frustration will occur. The first example is non-existence of the subject matter. For a contract to be performed, there is a reason as to why the parties entered into the contract. Where the subject matter or the reason as to why they entered into the contract does no longer exist, then they cannot perform the contract. For example, I decide that I would sell to you a table, and when I was done making the table or manufacturing the table, somebody stole the table. I can no longer deliver the table to you because the subject matter for which we entered into the contract no longer exists, and therefore we will be deemed to have discharged our contract or obligations. You can look at the case of Taylor versus Cardwell, where the court stated that where the subject matter of a contract no longer exists, the parties can be said to have been discharged of their duties. The second example to consider is where the person who is the subject matter of the contract no longer exists or is no longer available, then the contract cannot be said to be performed and therefore will be discharged. This means that sometimes you decide that I want to go to a concert and watch a person performing or the celebrity performing, but the celebrity in question will on that very day would either be sick or will be late or cannot come at all. In that situation, the contract in which you enter with the other party that let's go and watch the concert cannot be performed because the subject matter, which is the celebrity, is not available to perform. Then the contract will said to have been discharged by the parties. The case to consider is Morgan versus Mamsed. In this case, the contract was entered to hire a person to come and perform, but the person who was hired to perform was sick and could not perform on that very day. The court held that the breach was not by or was not in contemplation by any of the parties, and therefore it was said to have been discharged by frustration. Another example to consider here is where the subject matter is an event and then the event is cancelled. For example, you decided to attend a concert on 26th July, but on or before 26th July, it was announced that the place where the concert will be performed cannot be available, and therefore they are cancelling the concert. In such a situation, you cannot attend the concert, and neither can the other party you enter the contract with also attend the concert. In such a situation, it is deemed that the contract has been discharged by frustration. Another example is where the frustration is occurred by a legislation. I have already discussed in our previous video illegality of a contract by statute. For instance, where parties enter into a contract to perform a contract or to contract with each other. But then before they entered into the contract, they were very much aware that the contract was an illegal contract by law. That cannot be said to be a frustrated contract. It will become a frustrated contract where they entered into the contract and there was a law that allowed the contract to be legal. But after entering into the contract, the law operated, or a new law was passed to operate to make the contract that was legal between the parties become illegal. Then the contract was said to have been discharged by frustration by way of legislation which made the contract unenforceable or unable to be performed. In that situation, look at the case of RT Briscoe versus ACN. The court discussed discharge by frustration where legislation makes the frustration occur. The next thing to consider is, can a contract be frustrated under a lease agreement? The old law, or the case that decided otherwise, was the Fibrosa case. In that case, the court held that a lease agreement cannot be said to be frustrated by unforeseen circumstances. But that position of law has changed, and then the court has held in several cases that it depends on the terms of agreement by the parties and the number of years the lease agreement is to exist. For example, A and B enter into a lease agreement, but in the course of the agreement, there was to be a construction of a road which will affect the house which was leased to B. And due to that effect, the road would take like 10 years before it can be constructed. In such a situation, the lease agreement can be said to be frustrated by the construction of the road, since you cannot enjoy or you cannot use the house until the road has been constructed after 10 years. Meanwhile, the lease agreement is only for 2 years. But where the lease agreement is for a long period of time, then any situation or unforeseen circumstances cannot be said to frustrate the lease agreement. What is the effect of frustration in a contract? Under common law, it has been held that the effect of frustration is to terminate future obligations of the parties and not to affect past obligation. Under common law, if frustration occurs and parties have previously performed their part, the frustration will not operate for the parties to enforce their past obligations, but rather it will operate to discharge them of any obligations they have under their future obligations. This means that where they performed in the past, they have been deemed to have fully performed their part, the contract will exist between them. But if the frustration is to occur in the future, then their future obligations will be deemed to have been discharged by the parties. The case of Chandler versus Webster discusses this thoroughly, so I'll encourage you to read this case. Finally, we will be discussing the Ghanaian modification of discharge of a contract by frustration under the Contract Act 1960 Act 25, Sections 1 to 3. Under the Ghanaian modification, the first thing you have to know is that where parties enter into a contract and a frustration occurs, both parties become discharged, or they are discharged of their duties. In Ghanaian law, under Section 1 to 3, we do not consider past or future obligations. What we consider is, has there been a frustration or an unforeseen event that has caused the contract to be frustrated? If yes, then the parties will be deemed to have been discharged under the contract due to the unforeseen circumstances that has occurred. Another thing is that if a party pays, or if a party disposes of any property before the discharge occurs, they can recover the money. Under Sections 1 to 3 of Act 25, where frustration occurs and prior to the frustration, a party disposed of their property or they paid any money before the frustration occurs. If the frustration occurs, then the party that disposed of their property or paid any money can be deemed or can recover the money under the contract. Under common law, you cannot recover your money if it is in relation to future obligations. But under Ghanaian law, we do not consider whether it is a future obligation or it is a past obligation. So far as the contract was legal, you can recover your money under unforeseen circumstances that frustrates the contract. Another thing under the Ghanaian law is that any liability after the frustration event will cease to exist, meaning your future obligations will not be deemed to exist and therefore you will be said to have been discharged under the contract. I would encourage you to look at sections 1 to 3, which discusses the Ghanaian modification of discharge of a contract by frustration. Today, our discussion has been on discharge of a contract, and we looked at what discharge of a contract is. We looked at the 4 types of discharge of a contract, and we have looked at the Ghanaian modification under sections 1 to 3 of Act 25. I would encourage you to comment, like, share, and subscribe. And also let your friends know that we have discussed discharge of a contract and they should tune into the Law Lab. Once again, my name is Jacqueline Opoku, and here is the Law Lab. We dissect and unpack everything legal.